Sí, empiezo yo. Sí, muchas gracias.
Well, hi everyone, and thank you for joining us at the panel Contracting for Impact and Fair Value Distribution. I am very excited to be moderating this panel this afternoon with very dear colleagues that have a great deal of expertise on this topic. My name is Juan Diego, and I am Nativa's Impact Law and Governance Lead. And I work a lot with contracts that have impact components, and I'm some sort of a bridge between different legal teams that have to sort these out in different ways and to find creative ways to maintain and prioritize impact in their different agreements. From this sort of perspective, I encounter different strategies and ways into how this happens and evolves. And also, for me, one of the main areas of curiosity and interest is understanding the timeline of a contract and the timeline of a contractual relationship. In that sense, having expertise and one of my passions on the structuring of purpose-driven organizations, as I have mentioned in some other venues and also in the networking events, I am actively involved in the development of ISO for purpose-driven organizations and the decision-making for prioritizing well-being for people and planet. And in that way, I connect these two topics on this ISO that will be published next year on the decision-making that then organizations have to take in their contracting and in the different ways into the organizations have to embed their legal documents to prioritize exactly that, the well-being of people and planet, and the different ways into which we can define impact and so on. So today, we're going to start our panel with Gustavo, who I thank you, Gustavo, for being here today. And Gustavo, I would appreciate if you could present a real-life example on the concept of trust or the absence of trust and how it is influencing contracting, especially in impact-focused agreements, where stakeholders seek more than just financial gains. Because I understand, Gustavo, that in your work, that is a real starting point, sort of like seeing that a contractual relationship has much more than just financial outcomes. Thank you.
Thank you very much, Juan Diego. Please raise the hand if you like to drink coffee. Black coffee? Cappuccino? Espresso? With a shot of caramel? 2 billion cups of coffee are served every day, worldwide. When was the last time that you went to a place to drink coffee, regardless the country or the city you are or you were, and you ask the cashier, can I have a black coffee without child labor? Can I have a cappuccino that respects human rights? Please give me an espresso that supports women in Indonesia. I work for one of the largest restaurant chains here in Mexico. And we have integrated small producers in our supply chain. Products such as honey, marmalade, chocolate, coffee, vanilla, etc. And we have eradicated poverty in thousands of people in more than 20 years of experience. The way we approach to the communities is not by a contract or a legal issue or a commercial issue, or give me some samples, and I will let you know if the purchasing department wants to buy it. We start building trust. Because vulnerable people, normally, they don't trust you. And they don't trust big companies, as the one I work for. So the first stage, according to our experience, is to work with them so they can trust in us, and then we start having the samples and making the connection in a commercial way. And it can last from 6 months to 3 years, depending on how affected is the community with past experiences. So Juan Diego, trust is a main issue if you want to build a strong relationship and to make this panel, fair value distribution, a reality in the field. Thank you very much.
Thank you, Gustavo. And that makes me think of a workshop I participated this year in Scotland about the coffee value chain and how complex it is to get it, and how we can actually change the rules of the game with our involvement as lawyers through all the contractual documents and setups that get in all of that very big line until we get our delicious cup of coffee. And in that sense, I would want to move on to Jose Miguel, because we are talking here about this concept about contracting for impact. And I know, Josemi, that you work in this field for several years, and most of the work that you do, especially contracting, but also working with different professionals of different backgrounds, makes you have a unique understanding of this term, contracting for impact, and also understanding it in contrast with traditional contracting. So just from your practical perspective and your experience, what do you see as the key differences between these two concepts? And also, what practical advice would you give to anyone that is starting in this field, or to a party that comes to a lawyer and says, I want to do things differently?
Thank you very much, Juan Di. And I feel very honored and privileged to be sharing the stage with such great professionals, and the way you created the panel. This is not gender divided by any means. It's just like the sequel of topics that we're gonna talk. I just want to be clear. Exactly. No, for sure. That's for sure. No, I mean, no pun intended.
Sorry.
So, I feel we are very lucky that we're having this panel on the last afternoon, but it also puts a lot of pressure on us because we need to keep the energy going, and we really appreciate the show up. But to answer Juan's question, I think a lot has been said already throughout the different sessions. Deborah, you mentioned something earlier, that it's that one of the key elements when you are assessing something through the impact lens, regardless of the profession we're talking about, finance, law, whatever, it's having the heart in and understanding the relationships and the interests and the vulnerabilities that the different stakeholders have. So lawyers that leave their heart at home don't work here. It's the perfect recipe for disaster. So creating this sensitivity in our teams, in the communities that we are part of, is crucial, because sadly, law school is pretty useless in this sense, in general terms, unless you are a diverse student. But if we all think of our training, not so much, right? So creating that lens in the people that you receive from law school it's fundamental. Because at the end of the day, private law, if not law in general, is based on trust. If you think of the number of mercantile transactions that happen every day globally, there's absolutely no way that enforceability is the glue that sticks everything. Because if you think of the litigation that comes out of these number of transactions, even if we were in a hostile environment, the percentage is very, very low. The entire economy is based on trust. So this is obviously applicable to the field that we're working on. And particularly for people working in emerging markets like we do, but I think this also applies to mature ones. Understanding that whenever there's a vulnerable population at the table, they will be full of fear, and by default, they will think that the rest of the stakeholders are thinking a million ways on how to, pardon my French, screw them, right? And building the trust for the populations to feel comfortable with the structure, the vehicles, the contractual arrangements that you are bringing to the table is fundamental. It takes time, a lot of patience, a lot of listening, but it pays off. This year, these last 12, 18 months, I've been executing a state of a Costa Rican American entrepreneur that passed and that left his wealth basically to his employees and to conservation funds. And if we go to the essential, my legal work has been perhaps 3%, 5% at the most of the entire time that I've dedicated to the program. Listening, building trust, understanding their fears, trying to present information in ways that are understandable for them. It's fundamental. And I just want to point out a couple of points before I hand over the mic. How many of us are civil law trained lawyers in the room? Civil law. Common law? Okay. So I think it's one of the difference, the way we apply principles and values. And for civil law trained lawyers, perhaps what we're about to say, it's not that revealing, but the work that Deborah has done in relational contracts is fantastic, because at the end of the day, it doesn't matter how hard you work, you will not foresee every single possibility when putting together a contract. So you have to rely or relate to the values and principles that were behind the transaction, and that's why it's so important, the listening behind it, so that we can put all together. And if, just to wrap up, if I am to give an advice to anyone getting interested in the field, is be more a listener than a talker. Mm-hmm. And that's fundamental. I think it applies to both, to traditional law and impact law, but like in our field is crucial to develop that skill.
Thank you, Josemi, for your words. I connect them to my experience advising benefit corporations in different jurisdictions, in the way that I see, especially from non-lawyers in the room, and people that are very committed to the purpose of their corporations or their objectives, this passion of saying, like, why am I involved in a contractual negotiation that doesn't have the same spirit or gravitas than my bylaws, which are purposeful and that have, a mandate towards social and environmental impact. And then sort of when you are in a negotiation process between one of these purpose-driven organizations and an organization that it might not have that framework or that legal model or that structure or so on, being a listener and also being propositive at the same time to do things differently sometimes is the key element to getting to a contractual negotiation. And in that, I would want to transition from that preliminary part that both Gustavo and Josemi have talked about and come towards that during and after contracting as a different part of the timeline, because as you can see, I have asked my panelists to sit in a timeline format. And in that, I arrived to you, Marie, and about your work. Because in the conversations that we have had, we have talked about the different examples of non-traditional obligations that are in impact-focused contracts, and especially in these, catastrophic potentiality of having to go and have some sort of argument or discussion or move to arbitration or elsewhere. How do we handle disputes in impact contracting, and what do you see from your experience, your practical experience in your day-to-day work?
Thank you so much, and thank you for inviting me. Thank you, Sarah Ellington, for introducing me to this great community. It's my first time here, very new edition, and it's a really exciting time for me. So coming from the arbitration world, it's a bit of a tough question. Obviously, we know that there are new forms of contracting that have emerged. I apologize, I'm going to be a bit more academic than my colleagues, but there's some information here I'd like to convey. So I will talk mostly about infrastructure projects, as I've seen some of them in arbitration proceedings. We know, and it's obviously a great thing, that in mining, for instance, community benefit agreements have become standards. In infrastructure contracts now, the social and environmental safeguards are no longer buried in the annexes, but they are part of the chapters of the contract. There are a number of examples. I've seen a little bit the work of Total Energy, some contract where they have these community sharing clauses, where they have obviously the local content. Now they advertise that in Angola they have up to 80% local procurement on site. And also they have a number of community development clauses in the contract, which is obviously a very positive development when you look at the importance of these infrastructure projects for the host countries. So what happens in arbitration, and that's a tougher question, how are these commitments enforced? Because obviously if there is no enforcement, that's only good intent. So in commercial arbitration, I would start with that, arbitration based on a contract between private parties. So it's a really positive thing that it has become really part of the hard law of the contract, because arbitrators are first and foremost bound by the terms of the contract. So personally, I've never seen really disputes revolving around these clauses, but they are part of the contract and they could very much be, because again, arbitrators need to apply them. Most of the time they will be a little bit incidental, because obviously the core of the disputes are about performance, payment, delivery. But again, this is a healthy step forward. Now I'd like to talk about, maybe take the thing one step further, because there is a huge controversy in arbitration now around ESG, and it goes beyond the contractual clauses. And I would like to frame maybe a harder question on, irrespective of the contracts clause, if a project causes, an infrastructure energy extractive project, causes human rights violation, environmental damage in a given state, what is the arbitrator's role when the arbitrator is seized with a compensation claim from the investor, from the company? So this is quite acute when states are parties to the arbitration, because as states, they have to protect their citizens, they have to protect their environment, so they are likely to bring these considerations into the arbitration. And for those who know about investment arbitration, this tension is especially present in investment arbitration. Investment arbitration involves private companies suing states on the basis of public international law provisions, for instance, expropriation, for damage that was incurred further to state's conduct. It's a very specific type of niche arbitration, and it's become very, very controversial. So over time, arbitral tribunal seized of these claims. It's very investor-centered around investors' compensation. They have, of course, they cannot ignore anymore that also investors' activity can cause some significant damage in the host states in terms of human rights, in terms of environmental impact. So they have slowly started to recognize this and include it in their awards. But this is really unsatisfactory. I'm going to quickly explain why, just to show that there is a lot of work to be done. 2 awards against the state of Ecuador involving oil extraction by foreign companies and serious damage to the environment in this context. So Burlington and Ecuador, an ICSID award in 2017, no ESG clause in the contract. However, the tribunal found that the investor was liable for environmental damage, and they decreased the compensation awarded to the investor. So it was flagged as a moral victory because for the first time the state could get some compensation for environmental damage. However, the state was so dissatisfied with the outcome of the award that they tried to get it annulled. Why? Because actually the investor got over 250 million USD in compensation, and they got 30 million just to repair the environmental mess that was left behind. Same story in Bear Creek in Peru and Copper Mesa in Ecuador, where the investor lost its social license to operate, further to brutal repression of stakeholders' demonstration and also widespread pollution. Same thing, slight decrease of compensation. And the affected stakeholders were very unhappy because they realized that all their testimonies and the work that had been done by NGO was not reflected in the text of the award, and the harm was pretty much unacknowledged by the arbitrators. And it led, for those interested in that, to a very interesting documentary called The Tribunal, which is available on the Columbia Center on Sustainable Investment website, so very easy to find. So just to finish, so I would say in both commercial but especially investment arbitration, it's obviously imperative to reconcile our frameworks with impacts. And above that, I would say simply with the rule of law. So thank you very much.
Thank you very much. And I think that it's very interesting in the cases that you have shared with us. I know particularly about the Peruvian case, as I have studied it closely, and of course, that brings me to thinking about the ways into this could have been handled, or differently in the different phases of the contractual negotiation or the implementation, and then how things sort of evolved by the end. And in that way, I move on to you, Deborah, on the concept of relational contracts that you have been working on and studying for a while. And for me, hearing about these concepts in our different conversations along the years and reading a bit about it, what really interests me, and I think that really connects with the different interventions today, is about the way into different parties have different expectations of the contractual obligations and their duties, and also and these expectations might not be met or might not align with what happens in real life and what happens in the interactions that led to the implementation of the contractual agreements, or not, or if this doesn't happen in any way. So I would want to ask you, how do relational contracts shape the way, or can shape the way parties can delve into contracting for impact, and in which way can this tool be sort of a pivotal legal tool for lawyers to use?
Thank you very much. So if I could tell you a bit of an origin story of how I even learned about relational contracting, and I have to admit I came to it pretty late in life. I was on a plane flying to Oxford, where I was going to be talking about pay for success or pay for results contracting, and I had my Harvard Business Review issue with me, and I opened it, and there was this article about supply chain contracting, and I was like, oh, okay, I've got some hours to kill, so I'm reading something I typically wouldn't have read. And it was co-authored by a lawyer from Sweden and a businesswoman who's out of the University of Tennessee, and the Nobel laureate economist Oliver Hart. And they talked about how in supply chain contracting, in a very commercial context, more and more of these companies were using relational contracts to govern the supply chain arrangements they were having. And I was like, what's this? And they talked about how they use time, so this is building on your conversation that you were sharing with us, Jose Miguel, about they really took time to talk about the goals of the parties, what they wanted this relationship to be, and then some of them memorialized it formally in the supply contracts. And the whole point was it's very disruptive to break a supply agreement. You may have a series of these things, but to have to replace a supplier or replace a buyer is very disruptive to a business. So even though the contracts might be for a short period, the relationships were a long period if they were successful. And so people were willing to put that time in. And I'm like, why are we not talking about relational contracting in our deals, which are starting from values and shared values? So I tore that article out of the magazine, left the magazine on the plane, and then ran around at the conference, shoving it in front of everybody's face, saying, read this, read this. And then, because I have a lot of hubris, I called Oliver Hart up. Yes, I called this man at Harvard and said, hi, you don't know me. I'm a professor at NYU Law School. I read your article, and I'm wondering if it has anything that I could learn in impact investing. And he said, well, what in the world is impact investing? and we started a conversation. He ended up coming to the Grennan Center conference and was one of our keynote speakers, as was his co-authors. And so let me just say a word about Oliver Hart and why he won his Nobel Prize. And this is going to be very reductive. He's much more interesting than what I'm saying, but I've got limited time. He got his Nobel Prize for something that I would look at and say, what? He discovered that contracts are incomplete. Okay, talk to a lawyer. They're always incomplete. But then what he did is he went farther and he said, so how do parties fill in the gaps? And a lot of his study was about the types of things you were talking about, all of you, which is what happens when the parties are expecting the worst of each other. How are they protective? When they are trying to protect their selfish interests, or they assume the others are going to be selfish, where there's not trust. What are the things, what's the gaming that goes on? And he discovered that, and I hope that our innovative impact investing initiative folks hear this. He discovered that financial incentives can be quite perverse. So before we jump to impact-linked compensation, let's sit ourselves down and say, is that really the way to maintain an alignment of interests? I'm not saying it shouldn't be thought about, but in a more commercial context, he said, look at all the things that have gone wrong because we've dangled dollars in front of people to get them to behave a certain way. What works better is to give people agency, to give people power in decision-making, power in a relationship. And if that's true in the commercial world, why would it be different in our world? So I really have shifted, and I'm still shifting. This is a work in progress that you're seeing right here. But I'm really looking at in incomplete contracts, and our contracts may be even more incomplete than a commercial contract, because we're trying to do really hard things. And where does relational contracting work best? Complex, long-term contractual relationships where the goals are vulnerable to exogenous events outside the party's control. Okay, has anyone done an impact investment deal where that's not the case? I mean, that's where relational contracting works best. And so what are we talking about? We're talking about a decision about whether you're going to do rules-based contracting, which is what I've done all of my career. You know, if you don't pay me, this is what's going to happen. If you don't do this obligation, I get this, I'm going to come and do this to you. And to shift from a rules-based power relationship, because who sets the rules? The party with the power. Hence some of the comments you made about vulnerable populations. They're never going to get that power. So a rules-based way of contracting reinforces disparities in power relationships. Relational contracting gives you some tools to start sharing power, start giving agency to all the parties, because you really ground what you're doing in shared principles and values. Now, how do you get to that, where it's not just lip service? That's where you have to listen to what Jose Miguel's saying. It's hard. It takes a lot of upfront conversations. But it may save you time and wear and tear on the back end, which is where you were talking about, Marie. So relational contracting, when it works, not only helps parties align interests as they're negotiating, but gives them a process by which they can try to maintain that alignment of interest and expectations as the messy world in which we work goes forward. That is easier said than done. And a debate that's going on in relational contracting, and this is a space where I have not developed a view yet, because to be honest, I don't think there's the data out there yet. But how formalized should relational contracting be? And when I say formalized, should it be put into the four corners of the contract, or is it sufficient to memorialize it in writing but keep it outside of the contract? And a lot of that then takes us back to where Marie was speaking, which is, are you ever going to use a third party to enforce your contractual arrangements? And if you are, is that third party going to respect parties' statements of shared values and principles that would shape the decision-making processes if it's not in the contract? And even if it is, are they still going to give it deference? In common law, and let me put it in common law, where you have judges making law, we have found in the UK they have enforced relational contracting where it was in the four corners. Very skeptical of this in New York courts right now, okay? So it's a very interesting question of how much do you want to bring it into the contract, or it may be that the process of just getting people to memorialize it outside the agreement does something in setting expectations and giving you something to point to when behaviors don't fit what you tried to set up. Those who argue that you should put it into the four corners of the contract say this: judges often like to use the reasonable, and I'm going to say person standard, not reasonable man, person standard, and then the judge decides, what would a reasonable person do in this? Well, those who advocate for putting relational contracting into the four corners would say, it shouldn't be the judge's decision of what's reasonable. We should have said what was reasonable behavior. These were my expectations of your behavior. You didn't act that way. And we've told the judge that this is what we had all agreed it would look like. So again, I can argue this both ways, but I think it's a very interesting aspect for those of us who are starting to lean into no longer having binary, you do this, I do that, reinforcing power dynamics that are are already unfair, and starting to say, how can we not only align at the beginning, but maintain an alignment during these very challenging, very ambitious agreements that we're trying to put together when we're not in control of all the factors that are out there.
Thank you. Thank you. No, extremely interesting. And for me, I am realizing that we have around 10 minutes, which makes this conversation, we can either do it both ways. We can have some questions from the public, in case anyone has a question, or we can have a little conversation among us from the concepts that, oh yeah, there are questions. I really like that. Okay, so maybe I can hand you and Lynn the microphone, and then you can pass it along.
Who wants to start?
Thank you.
My question can be very quick. In the context of relational contracts, Deb, have you run into the concept of adaptive management?
People have not used that as the term, but that is actually what the process is that's going on. So these often have contractual governance provisions, these agreements, that basically say, this is how we're going to keep coming together. We're not going to wait till, oh, there's a crisis. We're going to keep coming together on a regular basis and talk about how are things working, how are we adapting to things that are starting to shift under our feet. So it's implicit, but I haven't heard people use that formal language.
That language is being used a lot by multilaterals, and one thing that it can do also is there are certain thresholds that can be agreed to so that there are shifts that are sort of predicted. So if, climate, things like that could be put in to protect parties. They're a little bit harder, but they are, if you reach this threshold, then we shift this way. If you reach that threshold, you shift that way. And then you could also have a process of continued negotiation as part of the contract.
Thank you very much for this panel. My question maybe it's for Deborah and also Gustavo. I would like to deep in the conversation regarding asymmetries. So let's maybe have an example regarding the coffee project. So a company that tried to create the trust relationship with a local community is going to develop a contract after 6 months, 1 year, 2 years, doesn't matter. And how about this third-party role? Who can be? I would like to listen from you. What profile of organization or this third party? And if you can share more about this, it would be very, very good. Thank you.
You can start if you like. Do you need a...
Vulnerable people, in most of the cases, they have low self-esteem. And when we arrive and they see you as a big company, they are not afraid. They are scared as hell. Some of them even think that you are going to take out their own lands. So you have to work first on the qualitative side and look at the eyes to them all the time. And after that, they start making the small changes. They are proving you. The first time that we arrive in a community, of course, they don't trust you. They want you to leave because you are not going to give money or food. The second time, there's a group against you because they are surprised. Oh, they came back. The third one, they think that you are going to do something bad for them. And on the 6 or 7 visits, when in our business point of view, there is no progress at all, and they say at the end of a 1 hour conversation, talking about their families, their kids, how was the weather affecting them in their crops, whatever. And they say, please don't go. stay and have dinner at home. They kill the only chicken they have, and they sit at your table. And then suddenly it's a magical change. Magical change. I cannot take you to the communities to see firsthand. I'm sorry, but anyway, if you come back to Mexico and you have 2 days, and because I like Lila very much, and if Lila likes you, I like you also. I can take you to see firsthand. So you are more than welcome to see the project firsthand and how they change. And then it comes the contract, honoring or whatever. But it's amazing the way they behave when they feel they have dignity and respect on the other side. Where are you from?
Brazil.
Brazil.
And I'm working with coffee projects.
Okay.
I'm from São Paulo, but I work in a project in the Amazon.
Okay, in the Amazon, okay. When are you coming back to Mexico? But let me know, and Lila, if you can give my information. It will be a pleasure to take you to the place.
So after I got hooked on relational contracting because of my friendship with Oliver Hart, a year later, I asked myself, well, relational contracting, at least how it's been discussed with me, is about the relationship of the parties at the negotiating table. The beneficiaries of a lot of our impact investment deals are not at the negotiating table. So I started then, this is my own evolution, okay? You might have gotten there faster than me, but I was like, well, how do you extend relational contracting to those who are not at the table? So I started asking people in that decision-making process, when people keep coming back together in a relational contract to talk about things that aren't going quite right, are they building in the beneficiary community's voice, whether that's a human voice, a nature voice, how are they building it in? And it's very nascent, and it's quite, and I say this, it sounds judgmental, but it's relatively crude what they're doing, people that are even trying, and I'm so glad they're trying, but it just shows there's so much more we could be doing in this space. So the next year after our relational contracting plenary, at the conference, I got these organizational psychologists to come in and talk to us. You may never want to come to a Grennan Center conference now that you know what I do. I got these folks in and I asked them, how do you hear the voices of those who are marginalized in ways that are not damaging to those people and also doesn't corrupt the information you're hearing? Because they've been taught to tell us what we want to know. And then we can smugly say, oh, see, they like what we're doing, right? And what I think, what I'm learning now and where I'm trying to grow to, and I think we've got a lot of room for those who want to be creative in this space. And if you're doing this, I'd love to hear your stories of what's worked and hasn't worked, and we'll make case studies out of them, is a lot of it has to do with the processes in which you get that information, and building safeguards around those communities and having standards set for what one does and what one doesn't do as you gather that information and discern how to act on that information. And so I think this is a space where if we're going into relational contracting, we actually, the good news is we've got room to hear these voices, unlike in a rules-based agreement where you didn't do it. And I'm like, yeah, I didn't do it, but this is why. Well, then this is gonna happen. Relation builds room and space for that, but we've got to do a lot more work then about how we gather that information in a way that's actionable and not damaging. Because we pretend in our world often that there can be impact return without impact risk. There's impact risk, and we have to be very, very careful.
Gustavo, I just want to hear your thoughts because you are full of lawyers right now. And you are the one that is working on projects on this value chain. So I just want to know if somehow you will take in this back with your group of legal team to say, let's do this fair trade contracts, or if you are already doing it, because at the end, that's why we brought you here, to get the perspective around how can we help as lawyers to get this, like all of the panel says, and this will be in practice. What do you think on a practical way? It's valuable if it's I think that you are willing to go back or something.
Well, Lila, first of all, thank you for the invitation. And Global Alliance of Impact Lawyers, you are agents of change. And the reputation of the lawyers is focus on business and focus on law. But if you give the profession the humanity side, as you are doing, because you are here on this event, I just have to give an applause for you and continue making the change that we need in the world. Sometimes we don't know how much good can we do in your day-to-day basis professional side. And every time you work on a fair contract and work having the right balance, of course you have to protect your client or the company you work for. That's the first social responsibility. But then also protecting others, that is not socialism, that's a responsible business. We are one of the most awarded Mexican companies in Mexico and worldwide, and we are the most profitable, according to the Mexican Stock Exchange with the public information. We have been the most profitable business in the last 15 years, and we are we are a very responsible one. So of course you can make a balance, thinking long-term vision, and sometimes regular business focus on transaction, more sales, best margin, higher profit. Sustainability is about not transaction, but transformation. Many business focus on short term. Sustainability is not short term, it's for the next 15, 20 years. And that means purpose. Because the companies and the business, you can see it as an end, or you can see it as a mean. And if you see it as a mean, the ends are we, the people, and the biodiversity and the ecosystems, and that's a complete transformation. So I'm completely honored to be here, Lila, and with this great panel, and I will promote you, the Gale Initiative, because all the good that you are going to have done, are going to do in the future. Thank you very much.
Thank you, and thank you for the questions. Unfortunately, we are out of time. Agos, we are out of time, right?
Yes.
Yeah. Yeah, I think that we can end with a call to action, and on that line, I just want to thank the panelists and also Gail, because I feel that contracting for impact, it is one of the ways that organizations can create long-term value through purpose and sustainability. And I would really appreciate if we can have a very quick call to action on the topic, and I thank you again for joining us today.
Okay, quick call to action, building on Marie's comments. I'm in the process of doing a survey of how dispute resolution is being used in impact investing. And so if you go to the Impact Showcase, you'll see a QR code. I'd love to have you be a respondent. All you're going to let me know is that when the survey's ready, you'd like to answer it. The goal is to have our quantitative survey completed. It'll come out in November, completed in December. December, January, and February, we're going to do qualitative interviews. And in the spring, we're going to tell you the landscape of how impact investing disputes are being resolved and any trends that we see. Is it formal, informal? If formal, what? What are the things people are putting in their contracts? Are they using them? If so, why? If not, why not? I think we need this landscape in order to think about how to build dispute resolution mechanisms that have impact at the center of them, not just bolted on at the end.
Thank you. I can only echo, obviously, Deborah's comments. There's a need for a new generation of arbitration, alternative dispute resolution practitioners who will, because I feel like I'm a little bit of the non-identified object here, because we don't know these new types of contract. No one has trained us. We don't even apply, I mean, when I say we, but the community doesn't even apply public policy norms. They are transactional lawyers who want to do justice, but they don't. So we do need indeed some training, and it's a conversation that I've started having with some of you here, and I'd be happy to continue. Thank you.
Well, my invitation or my call to action is for any of us, the next time we're in front of a transaction, to include as part of the scope of work up to three calls or meetings in order to get familiarized with the context, with the drivers, with the purpose behind the transaction. Billable, non-billable, doesn't matter. But it's so important, and more important than anything, invite a young associate, a paralegal, an intern, whoever is young talent around you, to be there, to witness it firsthand, and to guide him or her through the entire transaction, end to end, because that's the way we create a legacy.
It's not a call to action, it's just a thank you. Because you are positive change makers, because you are here. And that's it. Thank you very much.
Good.
Very good. Muchas gracias.
Qué gusto, Gustavo.
El gusto es mío, ¿eh? Lo
Estamos
mejor,
en contacto.
Lo mejor. Creo que buena foto, ¿no? ¿Aquí? ¿O aquí adelante? Sí, sí. ¿Cómo estás? Bien. Soy Margarita, mucho gusto. El gusto es mío, Margarita.
Entonces me interesa saber si se puede, qué tipo de mecanismos implementan ustedes para continuar darle seguimiento quieren conectar con industrias muy complicadas.
Sí, sí.
Sí, vivo en Mallorca.
Paraíso. Con mucho gusto platicamos. Si quieres, abre tu canal y que nos yo trabajo en Somos y Somos básicamente es una plataforma de Somos empezamos a trabajar en la industria, con abogada, con organizaciones, trabajando en las Naciones Unidas, me doy cuenta que hace falta un actor que vaya con el cuidado con lo que está haciendo las comunidades. Entonces, un poco lo que nosotros hacemos es ayudar a la comunidad a recaudación de en el sentido de que poder crear ese link con comunidades, ver cuáles son las implementaciones y mecanismos que se están teniendo para poder asegurar la formalidad de ese café. Porque decirlo, cualquiera, ¿estás de acuerdo? nadie va a ir a verificar
Pero
a la
luego,
montaña.
yo siempre digo es que los contratos son súper importantes. Operar sin hacer cosas. Pero ¿qué pasa? Yo me dedico a esto, a la práctica y empezar a encontrar esos casos. Entonces me interesa mucho saber cómo desde ustedes.
Voy a leer todos los antecedentes de la Constitución, considerando.
Como voy a la comunidad ahorita en noviembre.
Te dijeron 2 horas cada quien, ¿no?
2 horas cada quien, sí, que era lo mínimo. Que era lo mínimo, o sea, es el... ¿Sabes? Nada más que perdón. ¿Sabes que si nos mandas alguna señalcita con los tiempos para no pasarnos? Sí, una tarjeta. Sí, pero ¿sabes qué? Luego se nos pasa, luego alguna cosa, ¿no? O sea...
Son plenaria, o sea que es como que ahí vienen todos a su panel.
Súper.
Porque la tienen que romper como se oye hablar. Gracias.
No, hombre, encantadísimos.
Con los tiempos.
Está ahí, pero bueno, yo a mí se me pasa.
Ah, ya lo vi.
Pero si quieren, haciendo una señal, más o menos son 10 minutos.
10 minutos. Es que sí, yo luego me arranco y...
No, yo a mí me pasa que luego se me va la onda y luego no veo el
Lo bueno
reloj.
es que tú eres el último.
Sí, yo no, ya. Sí, yo ya. No,
Ya, te
tú estás
regalamos
aquí
todo lo
y no,
que
y luego te
queda.
dicen, oye, ya nada más te quedó un minuto para hablar, por favor.
Exacto.
Ya, nada más quedó ya se comieron todo el tiempo. Sí, un papelito amarillo o algo así, un post-it para los tiempos que nos...
Ah, hay una persona que se...
No, pero no hay.
No.
Entonces, por eso
No,
aquí
para no
está
confiarnos.
tiempo ahí.
Un post-it o algo así. Sí.
O sea,
También aquí está
de-
representación, no sé si este sea el... Pero ahorita lo conseguimos. No se preocupe.
Ya, se supone que 4:30. Llevamos como media hora. Empezaba a 4:30.
Sí, podemos empezar.
Ajá.
Entonces podemos ir.
El micrófono. Sí.
Bueno. ¿Está bien? ¿Listos? Well, thank you, everybody. Let's give it a start in a minute of time. So welcome. It's a phenomenal pleasure to be here with you. We're going to thank Gail. We're going to thank the organizing committee. We're going to thank the members, the sponsors, everything for making the space to be here. We're here to talk about strategic litigation and how legal opportunities can enhance the protection and promotion of human rights and climate. Gail's motto, and I'll read it, is to be a community of legal leaders who are using the practice of law to have a positive impact on people and the planet, further enhancing that lawyers are uniquely positioned to facilitate change and support the movement towards a more equitable system. And I believe there's not a better definition just to define the guys that are sitting to us with as panelists. I'm Martin Michaus. I'm Senior Associate at the Hogan Lovells City, Mexico. But because one of the most irritating things, aside from traffic in this very vibrant city, is when a moderator takes a lot of time to speak about himself, I'm just gonna give a brief introduction about the three panelists here, and I'll say the mic to them because, let's be honest, you're not here for me. First of all, we have Aline Vieira de Souza. Aline, thank you very much for being here. Thank you for making all the travel from Brazil. Aline is a PhD candidate in public administration and governments and a specialist in corporate law. She's also partnered at SBS Advogados and an award legal scholar for civil society organizations. She has served as a consultant to UNESCO, and she has acted as an advisor to the General Secretariat of the President of the Republic of Brazil. We also have María Eugenia de la Fuente. Maru, great to have you here. Mario is the chair of the board of directors of the Mexican Center for Environmental Law, or CEMDA. Mario is a lawyer from our hosting university. She holds a diploma in U.S. law from Georgetown University and has a master's degree in business law from the London School of Political Science. She has been a partner and founding partners of different law firms here in Mexico. She has participated in a wide range of congressional discussions that led to central reforms in environmental regulations. And she's also an environmental law professor here at the Universidad Americana, as well as Universidad Anáhuac, Quitam, and Ceris. And last but not least, a man that really does not in an introduction regarding human rights litigators in Mexico, we have Jose Mario. Jose Mario, thank you for being here. Thank you. Jose Mario is a law graduate with honors from Escuela Libre de Derecho and holds a master's degree from corporate law in Universidad Americana. Jose Mario has been the president of the Transparency Citizen Council from San Luis Potosí, the president of the Mexican Bar Association, a member of the Advisory Council for the Prosecution of Justice in the State of San Luis, and a citizen advisor from the now extinct INAI. He's also a partner of Fufete La Garza and a law professor at the Universidad Autónoma de San Luis Potosí. In 2012, Mario founded Renace Capítulo San Luis Potosí, an NGO focused on practicing law for social cases, accompanying cases of illegally incarcerated individuals, which in 2023 transferred or transitioned to Perteneces. So, getting that out of the way, I'll ask the first question for the panel, and I do invite you to put a lot of attention because this is a really very fantastic mix of what is really strategic litigation and how NGOs do serve a purpose and of impact. So the first question, I think in your experience, how have groups like civil society organizations have helped move forward strategic litigations in climate or human rights? I don't know if there's some series of cases or stories that you want to share with us. Obviously, the question is for all three of you, but having an international guest speaker, I think we can start with Aline.
Thank you very much. It's an honor to be here. Danny, if you can help me, there is a presentation that I would like to show. I'm not a litigation lawyer, but I work a lot with civil society organizations in Brazil, and I know all the efforts in order to do advocacy in different ways. And because of that, I coordinated a research that I'm going to present here today. The first thing that I would like to mention, Brazil is a civil law country, and our constitution obliges everyone to care about the social and environmental issues in the country. So the state, companies, citizens, and CSOs. So all of us, we have like this duty in order to achieve a good environmental and social place for everybody. Okay, next one. Good, thank you. Although, when we are looking to the access to the judiciary, executive, and legislative power, what we are seeing is that there is a gap in the use of the judiciary from CSOs. usually when they are trying to create a better environment, they are going to do it with the executive or legislative power. The advocacy strategies, usually, they are trying to create better legal frameworks or change the legal frameworks that exists. But accessing the judiciary is not something that is very common for them. Oh, no problem. It's interesting to know that just some entities are eligible to file constitutionality control actions. And businesses, companies, they are not allowed to do this. So the President of the Republic, the presidency of the chambers of the deputies and the Senate, the governors of all the states that we have in Brazil, the Bar Association, and CSOs. All these entities, they can file, they can start a constitutionality control actions in our Federal Supreme Court, but companies, they are not allowed to do it. Although that, since 2016, there was a reform in our legislation, and now all people, it doesn't matter if it's a company, a CSO, or individuals, all of us, we can be an amicus curiae for different types of lawsuits. So this is something that starts to open a place to the businesses to be more active in the judiciary and act as amicus curiae. So I would like to present some pieces of information regarding this study that I coordinated in Brazil. It's available to download, but it's in Portuguese. So if you want to try to improve your Portuguese, you can do this. So there is a missed opportunity. Actually, just to explain to you, we studied almost 160 cases. There are still pending the decision in our Federal Supreme Court that are highly important to the CSOs in Brazil and civil society organizations in Brazil. They work with a lot of very important thematics, such as environmental law, civil law, and so on. And we studied these 158 cases, and what we realized, there is a scenario of a missed opportunity. 86% of these cases of high relevance to CSOs have no amicus curiae. And when we find this amicus curiae, there is a fragmented engagement. So what we are going to see, there are several human rights and civil society organizations that are acting as amicus curiae in these relevant lawsuits, but most of them, they just participate in just once or twice. They are not like doing this as a strategic way of doing advocacy. Also, companies can play only, companies nowadays, they are playing only a minor role as amicus curiae. In this study, we found just one business, one company that was presenting itself as amicus curiae. So this is a scenario that I concern a lot. And I think it's very important to develop legal and strategic capacities to strengthen the civil society organizations and also impact businesses in order to be more, to do more things in our federal court, to formulate cases that can have a lot of impact for collective impact, not just individual one, act as a network connecting advocacy, academia, and social movements, and use litigation not only as means to redress, but also as a tool for political advocacy and social standardization. To finish, I would like to say that for CSOs in Brazil, maybe it's a lack, this gap of accessing the judiciary. They are afraid of the judges, you know? So this is something that there is a lot of costs a lot of technical barriers that is applied in this relationship, that they are not going to find the same barrier when they are trying to do advocacy with the executive or the legislative power, for example. So this is a barrier that we need to think more about this, but even though I think it's important to just start this conversation with these pieces of information. Thank you.
Thank you very much, Lynn. And I do agree with you. I think on screen number 3, it's really a core issue of this panel, right? Using litigation for purpose of political advocacy and social standardization. That's what we're aiming for. Maru?
Well, thank you. Related to the question that you're just asking, I have 4 main aspects that I would like you to take into account, that maybe you're familiar with them. It would be that we need to push the boundaries of existing laws right now, and that's the most obvious one. And then we must be looking for community outreach. It's an important relationship between CSOs and how we relate and engage with communities. Also, we have to be holding governments accountable, so there's another important issue there. And the 4th one that I would like to consider is mobilizing public policy. So these are one of the 4 aspects that I consider that CSOs have more relationship in pushing the strategic litigation forward. So I will start with the first one that I mentioned, which is push the boundaries of existing laws. And here, as you may know, and as many of you are aware of, if we went into the beginning of the 21st century, we would realize that environmental law was much straightforward and limited. And so advocacy lawyers were always trying to break these boundaries and make it much more expanded in the way that it was thought and litigated. So in the last decade, I can see, and you might saw, that there's a connection with the environment, with climate, and with human rights. This connection might be obvious right now for all of us, but it wasn't obvious 20 years ago. So it's been pretty recent that this has happened. And part of this achievement, I must say, is attributable to CSOs. So CSOs have been litigating at international and domestic level, trying to make this connection and make the courts understand this relationship between the environmental law, between the climate and the human rights. So how have we done that, and how has SEMDA participated in these achievements? And part of the crucial things is that we've been provided great amounts of information to the courts, domestic level at an international level, and monitoring how governments act before this information, and giving all these arguments and opening the discussion of how there's a link in trying to break this gap that exists between human rights and the environment, right? So now I think we've breached this gap, and we are in a different situation, but it didn't used to be like this. And this broader perspective has been reached like this, and now we see that we're closing a circle, right? Because many of the conceptions of human rights and environmental law that went up to the top at international level were nurtured by the domestic cases and the domestic information that was nurtured to the international courts. So we had testimonies, environmental impact assessment arguments that were brought up to the courts, and the community impact on the decision making. So all these arguments made the courts to realize, and then to, for example, recently this year, we could see that the International Court of Justice and the European Court of Justice and the Inter-American Court for Human Rights have made some statements related to this. No? They have recognized that there is an environmental right attributable to all persons, and that should be considered a human rights issue. So these statements are really strong, and now closing the circle, they are going down as a cascade into domestic law. And this is very important, and it's really strong for domestic law, because as maybe you may know, the ones that are here that litigate or are familiar with the Mexican system, but we've been having some trouble regarding some of the most basic instruments for litigating human rights here in Mexico. So that takes me to the next argument, which is community outreach. And as you mentioned, and other panelists have mentioned, and I heard the last panel was talking about this, about community outreach, and how communities directly suffer from environmental affectations and violations to human rights. So they are the first ones to get the causes of these violations and these affectations to the environment. So they are one of the first interested in trying to make a change, and that collaborate with CSOs and make these engagements in order to make this a strategic litigation and find solutions that change basically the perception of how these things work. And I made an echo with what you were saying in the last panel, Brendan, everyone, and saying that when you reach a community, sometimes it is very difficult because they're really skeptical about why are you trying to engage with them, and why are you trying to make a contribution to their territory or their rights, no? Like, what do you want in exchange, no? What are you looking for here? And so once you make this engagement, then the wheel starts turning on, and then it's much easier to have an impact on what you're looking for and the achievements. Here, I would like just to mention two cases. Many of you might be familiar with some of them. Some have had a lot of mediatic impact. One of them is the Wirikuta case, the Wixárika case. We've been litigating for more than 30 years, so we have a bunch of infinite cases regarding strategic litigation. But I like this one because it exemplifies the difficulties of strategic litigation. This is a community, a population, the Wixárika. Maybe you're familiar with the popular name, which are the Huicholes, but it's not the correct and appropriate name for the population. But they have this enormous sacred territory that's called the Wirikuta. And the Wirikuta exemplifies the origin, and it's very important part. I mean, the Wixárika people wouldn't be able to be Wixárika people without the Wirikuta, because it's the origin of their existence. So in this case, there were 78 concessions granted for mining, and that represented the 70% of the territory of the Wixárika. And so there were several amparos, many amparos were promoted. And what I want to tell you, it's been 14 years since we promoted the amparos over this case. And we were granted a suspension under the amparo. So the suspension was granted, and there is no mining activity in the territory. But 14 years after, we're standing here 2025, and we do not have a resolution, a final resolution over the case, no? And then this is like one of the cases I want to mention. The other one is the Independencia Aqueduct, which I don't know if you're familiar. You might be familiar with it because of your relationship with San Luis Potosí. But it was also a very mediatic case, because this was the Yaqui tribes that were in San Luis Potosí. And suddenly, there had a big drought in Sonora, which is a state in Mexico, and all the water that was available in the state had to be entubed and taken into Hermosillo, which is the capital of Sonora. And in this case, what happened is that there were 35 affected communities in the area of the Yaqui River. And these 35 communities, even some of them, stayed without the possibility of having access to potable, drinkable water, no? So what happened? Well, everyone started leaving the territory. So there was a big problem with that part. So then we promoted an amparo where it went up to the Supreme Court, and the first court of the Supreme Court of Justice acted in favor of the tribe and acted in favor of the resolution, saying that human rights were violated and environmental law was violated, and that something had to be done, no? And finally, well, one of the mitigation activities that were considered here was that an aqueduct for the 35 communities had to be built. As of today, there is no aqueduct that goes to the 35 communities, no? So we have all these really big cases that we are all the time fighting for, and but what happens? It's all really bitter. No, it's not all bitter, because these cases establish a precedent for what we're doing, and for many other cases that have been following this case. So what happens here is that, for example, we reached, like the Court of the Human Rights National Commission in Mexico established some recommendations, giving the reason to the population, and saying that the violations were made and that something had to be done. And then there's a recognition of access to justice and public participation. So many things are won in the process, and maybe not in the conclusion of the process, but during the process we win many of these things. And some of the other aspects is holding governments accountable. And regarding holding governments accountable, well, as you know, there is a need for compliance with international and domestic laws. That's what we are constantly arguing before courts, and trying to negotiate with authorities, and even having collaboration with authorities, and trying to explain to them that maybe there is a non-compliance in some specific issue. Here, we have a really recent case, thank you, which is the case in Cozumel. I don't know if someone has opened the newspaper or heard about it in the news, but our recent win, the most recent win, is this case in which there was the intention of building a 4th pier in the island of Cozumel. And what happened here is that we promoted also an amparo, because in the environmental impact assessment, in order to obtain an authorization, they did not consider, the Semarnat, which is the environmental authority in Mexico, did not consider that there was a reef right there where they wanted to build the pier. No? So we established a collaboration with Semarnat. We got close to Semarnat, and we explained that this authorization was being granted without considering one of the most important factors, that there's a reef there. You have to take into account in the assessment that you can't just destroy the reef. No? So Semarnat was surprised. The information wasn't granted, and this is an example of collaboration with the authority, because they were really grateful with us, because we showed them the reality of the assessment that they were making and the errors in the assessment that was going on. So, okay, there was a definite suspension through amparo, and just a little bit further away on time, Semarnat revoked the authorization. So the authorization was revoked. Why? Because they didn't have the due elements to make the evaluation, right? So this is an example of collaboration with a win-win with the authority, and how we managed to get a good result, no? Now, regarding community here, it is good for you to know, or you should know, that no one wanted this pier. Not the fisheries, not the population, not the community, not Mexico, not the lawyers. No one wanted this pier, right? So here I come up to the issue that we were talking about, where it is important not just to comply with law, but to know that what you're doing is acceptable, and it promotes a better future for so many people around you, right? So all these people didn't want it. There it is. They can't construct it. Lost tons of money in the investment, because it couldn't be done. There was no acceptance at all with this issue. So that's the last case that we've had a result from. And then mobilizing public policy. Mobilizing policy is like totally straightforward. It's creating awareness and exposing injustices, right? So it is really challenging, inadequate policies that exist. But here, I think education comes forward, and then a culture comes forward, because you can't have adequate public policies when you don't have a society that promotes these public policies. So these are the 4 things that I would like to talk about, and I will just let Jose Mario follow my thoughts. Thank you.
Thank you. It's great to be here today. As it was mentioned, I'm president of an organization called Perteneces. Basically, we do 2 things. One is reviewing cases of people that are wrongfully incarcerated. In this, we do it in San Luis Potosí. I will explain on that. And also, we have a strategic litigation regarding schools, water, and some cases on health matters. And for the first question, I just want to use two examples of what we have done in Mexico regarding this strategic litigation. I will use the case that we have last year, the San Juana Maldonado case. San Juana is a woman that was incarcerated in San Luis Potosí. She was accused of a kidnap in Mexico. And she has been incarcerated for 13 years when we got the case of San Juana. So we start reviewing the file. The file was like a very huge, 14 very huge files. And we review page by page all the criminal file that was brought against San Juana Maldonado. And we found out two very important things regarding this conviction. She was already convicted for 30 years in prison. The case was finished. He didn't have any appeal or amparo. The case was finished and she was just serving the time in jail. But when we study the file, we find two things. She hasn't had a good attorneys that understood the case and brought the case against criminal courts. And the other thing is that there was not a piece of evidence in the 14 files that we study that show that she was involved in kidnapping. No? So the only legal action that San Juana could brought was forgiveness process that we have in Mexico. And in the case of San Luis Potosí, this process has to be approved by Congress. So we have to file a petition to the Congress of San Luis Potosí to show that she was wrongfully convicted of the kidnapping accusation, and that the Congress people in San Luis Potosí has to study the case and decide if they give this legal forgiveness to San Juana Maldonado. It was difficult because in Mexico, when you talk about kidnapping, it's a very important and social crime that has a lot of impacts in Mexico. So when you say that you are going to take a case of San Juana, which is accused of kidnapping, well, nobody in Mexico wants that kidnappers get out of jail. Basically, that's something which is in the public mind. So we have had to build a very important strategy in order to explain to the people how this case had to be think using human rights as the basis of the case. It took us a year in order to talk to the Congress people, and to explain to the Congress that San Juana was innocent and she should be free. It took us a year for that. Last year, around September of last year, she was the Congress obtained the freedom of San Juana, and she was free, and she's now studying law in San Luis Potosí. So she's going to become a lawyer in the coming years. But also in this case, San Juana case, I also want to bring to your attention some other important aspects regarding women incarcerated in Mexico. There is a lot of women in Mexico that are being incarcerated, that they have very long sentences, and they weren't correctly defended, they weren't correctly represented by lawyers, and there is no evidence. There's basically poor people that was caught by the police. They didn't have any chance to understand what was happening, and they're at the moment in San Luis Potosí, we're trying to obtain also this kind of resolution for 50 women 15 women that are in the similar situation of San Juana Maldonado. So it's important to understand that in Mexico, if you look for a woman in jail, you will find poverty in most of the cases. I would say 95% of the cases in women incarcerated in Mexico are poverty, and also they didn't have the opportunity to present the case before a judge, and they weren't correctly defended by a lawyer in 95% of the cases. And most of these women, at the moment, they don't have any chance to present an appeal or an habeas corpus or an amparo or nothing. The cases are closed, legally speaking. So the process to obtain the freedom of these women, not just in San Luis Potosí, for the people that are coming from outside of Mexico, it's a state in the middle of Mexico. If you look around in Querétaro, in Mexico City, all around the country, this is the same situation for women in jail in Mexico. So it's something that has to be brought up. We need more lawyers working in these cases, because there is a lot of work to do. I don't see many organizations caring about women in prison. They're mostly abandoned also by their families. It's very expensive to have someone in jail in Mexico because it takes a lot of money to visit. It takes a lot of money to be close to your relative. It is very expensive, and if you take in consideration there are poor people, it's very difficult. When I was speaking to San Juana in San Luis Potosí, a woman reached me and she asked me for a favor. And I thought she wanted a legal favor or something about representation, a legal representation. And she said, no, I just want one favor. I haven't visited, my family hasn't visited me for the last 8 years. I haven't seen my kids for the last 8 years because they live in Guadalajara and I'm here in San Luis Potosí. They don't have the money to come here to visit me. So I'm just asking if you can help me so they can visit me. We arranged that. It was something that was very, very impressive that you have these kind of cases. But this is very common. It's not. I'm not just telling you this like a kind of a rare case. This is the normal cases in Mexico. So I bring you to your attention that we have to do something about. Lawyers have to do something about women in Mexico that are in prison. There is a lot of work to do, and there is many cases like San Juana Maldonado that need to have attention, legal attention. That will be one case that we have last year, San Juana Maldonado. And the other strategic litigation that we are doing a lot in Mexico is regard public schools in Mexico. We have found out that public schools in Mexico are abandoned. They don't have any kind of infrastructure. They don't have any playgrounds. They don't have any internet. Sometimes they don't have any roof. They don't have the conditions in which little boys and girls are studying are, believe me, very, very dramatic with a lot of problems in the infrastructure of schools. So what we did, these are very pure communities in Mexico, very abandoned communities. They don't understand what are human rights. They don't understand what is amparo. They have never been to a court. They're communities basically that are abandoned by government and by ourselves and the society also. We are also responsible for that. So when the guy here who was speaking about the coffee, I forgot his name, no? That he talked about coffee. I was thinking about this. When you reach these communities and we said, we want to help you with your school, we want to present an amparo because this is a human right, an important human right for the kids, the education, the conditions of the schools, they feel afraid. They don't trust you. They feel that you're going to take the land. They're going to take the community. So we understand something which is very important, because lawyers sometimes don't understand this approach. You have first to translate what the human right in this case of education means. And you have to talk to the community, talk to the mothers, talk to the fathers, and it takes months. in order to build trust with these communities. So this is not like a legal problem that you are going to go to a community with some paper and you're going to get a signature and then you will file this petition. It's not going to work that way. It's not that simple. It's much more complicated. And we were talking about the difficulties lawyers have in order to reach these kind of communities, in order to talk. We don't have the training to talk to these kind of communities. We don't have the understanding of the community. We don't have the understanding of the social and poverty situations they have. It's difficult to understand because we live in a very different situation. So first of all, I think we have to understand the needs of lawyers to reach these communities. So we have to train ourselves in a different manner in order to be able to have the tools in order to go to these communities and to explain to the communities what is a human right, what does it mean, how can they present a legal action. And it takes a lot of time. They are afraid. They are not used to go to trials. They don't feel comfortable with that. So it takes a lot of time. It takes a lot of time. Then when we do that, what we establish as a strategy is that the amparo, the habeas corpus, similar to an habeas corpus petition, was going to be signed by the kids, by the young kids, represented by their parents. So the petition that a Mexican judge receives is a petition filed from the kids to the judge, it's changed everything. Because it's not the organization, it's not something doing what they have to do. They have to be able to present themselves. This is part of the education process. They have to present themselves the amparo petition to the judge. No, so, which is also very important because we have to teach these communities to change the way they think. These communities have been built for many years back into a model. They are very well trained to ask for favors to the political leaders of the community. The understanding of the community is like that. When they see the political leader, they ask for favors. So the way they manage to keep the school for example, to have a roof in the school is when the presidente municipal comes to the community, they ask for a favor. They ask for a favor. They don't say we have a right, this is a human right, and we are going to demand this right. They don't do that. They are built in order to ask for favors. We have to change that also. We have to change that. In order to ask for a favor, you have a human right, and you're entitled to be heard by a judge if this human right is not respected. So this is also an educational process for them and for us also, for us. So we ask for these amparos, and in Mexico, the amparo petition to a federal judge can be also supported by a suspension, which is a resolution from a Mexican judge which immediately issues a judicial order in order to establish to the educational, in this case, the educational authorities to improve the school, change the playground, change the bathrooms, put the ceiling, improve the situation of the conditions of the school. No? So I say to the team, this resolution, we obtained this kind of resolution maybe in 4 or 5 days from the petition day. So it's very fast in order to have these kind of resolutions. So we changed the school very fast. And we have, at the moment, we have filed 50 claims of amparo regarding the schools. We have changed 50 schools up to date. And we are asking for Mexican lawyers in order to help us because there is also a lot of work to do in this area. There is a lot of schools that need to have an amparo. There is a lot of communities that need lawyers to sit with them, to explain to them, to hug them, to understand them, and to understand that our position is a very important social position with these kind of communities. The school is not going to be changed. No government authority cares about the school. Nobody cares about that. These are very poor communities. We have to care about these communities. We have to go to the community. We have to hug the community. We have to teach the community in order to have the ability in order to change the situation. And in our experience, these communities, when they do this kind of amparos, then they ask us, what another amparo can we present, no? Because we don't have medicines, we don't have doctors, we don't have any, so they start changing the way they approach the relation with the authority. So it has been a very thoughtful experience for the community and also for ourselves. I will leave it with that.
Thank you, Mario. And I think it's a fantastic way to put it, because that's a prayer of plaza. I believe you know that Hollywood movies are made from passionate lawyers, as the ones are hitting here. So if any have an idea, I'm going to be the copyright lawyers. Okay, so just for the company. Now, in terms of what you three have spoken, one of the questions, especially in times of that, to put it politically correct, are very downing in terms of access of justice, of very volatile democracies, of very authoritarian governments. How, looking ahead, in order to find a positive note, how would you think strategic litigation could be more effective in the future? Are there any partnerships? Are there any ideas? Are there any tools that you think do make a difference? Because at the end, what we're hearing a lot here is you need to build trust with the client, and that's for certain. You need to convince many clients to actually want to engage with the government, and that's a very hard and difficult task here. But what will be your views, futurely speaking, on how can strategic litigation does have a further impact of what has been created? I don't know if Mario, you want to take further question.
Well, thank you very much. That's a big question, but I've thought about 4 things that would work. I think that we should definitely avoid any setback in legislation. There have been so many generations working to take us where we're standing right now, that when you realize that there are so many setbacks and people trying to destroy in a second what so many years and so many generations have built, it's really frustrating. So I believe we have to do a lot of lobbying, a lot of communication with the legislative power in Mexico, because, for example, I don't know if you're familiar with it, but the most important mechanism for the defense of human rights in Mexico right now, as Jose Mario mentioned, it's like the habeas corpus, and as any person that works with OSCs here in Mexico may know, is the Amparo Law. We use the Amparo Law all the time. Why? Because the Amparo Law protects fundamental rights against acts of authority. That's what it does. And the Amparo Law was created in Mexico, as maybe you didn't know, and it was exported to many Latin American countries and other jurisdictions around the world. And it was copied because it worked really well. So right now, the Amparo Law is under threat by the legislative powers in Mexico. And 3 issues that are being discussed right now in the Deputies Chamber and in the Senate Chamber are suspensions, which are the ones you also use, are retroactivity of the law, which under our constitution, it's unconstitutional. You can't have retroactive laws. Laws must never be retroactive, because then you take away all certainty of what is being decided, right? So they're discussing the retroactivity, the suspension of the law, and also the legal standing of the law. So OSCs were also really nervous with this, because right now, when you have the objectives on your statute of incorporation regarding environmental protection, that's enough to have a legal standing. However, this might change in the discussion, so we're going to see what happens with this. But this reflects authoritarianism in our government. So we must work hardly, everyone here, and all of us must be really interested in having an approach before the legislative authority and trying to make them and explain them that this can't be done, right? Because their main purpose is a tax purpose. They want to get money and fund themselves, but they're having a lot of implications that have nothing to do with taxes, so we must work with this. So I would say that this is one of the issues I would be working on hardly. And another one is judicial training. We do not have environmental specialized courts in Mexico. So judicial training is very important, because I was talking with some of you later in the garden, and I was saying that in Mexico, you have to flip a coin and just pray to have a good judge that resolves your case, right? Because you might have someone that is progressive, that knows about environmental law or human rights, but you might have someone that has absolutely no idea what he's doing there, right? And then come some conferences and people that have talked about artificial intelligence. So the new one is that they go into ChatGPT and try to make ChatGPT resolve the case and go into the understanding of the environmental and human rights law when maybe lives and health is at stake, right? So it should be taken more seriously. And what we do at SEMDA is that we have some programs, systematic programs, where we go and train judges that come into action, and then we train them in order to explain to them the complexity of environmental and human right cases. That it is not civil law, it is not administrative law, it is not criminal law. It's much more complex because it has so many actors, so many complexities in the results of and the considerations that should be taken. And here I would like to put some examples of what I'm saying with some cases. And one of them was the Caguama turtle in the North Pacific. And here what happened is that the courts considered that Semarnat had 3 days, 1, 2, 3, to determine the amount of turtles, of Caguama turtles, that would be, that if killed or caught, would have a menace in the subsistence of the Caguama turtle. What? So it's impossible. It's something that if you're familiar with, you need science, you need technology, you need fisheries, you need communities. There are so many actors involved that you can't believe that this is a decision from the court, right? So it expresses the lack of information that they have in this kind of resolutions. The other one is a solar park in Yucatan. Here, the judge that followed this case and that ruled in this case considered that because we were talking about renewable energies, it was environmentally friendly, right? So there were 600 hectares that were going to be cut off from the forest. And even though that are going to be that, they thought, no, well, it's a solar park, so it should be totally environmentally friendly. No, but you're cutting off 600 acres, no? So that was another thing. But finally, I know I'm over time here, but I will work on making stronger institutions that are well-funded, and cooperation, as the one I explained in Cozumel, is important. And then planning lawsuits on a long term is also important, and making and planning engagement with the communities in an appropriate way, and they feel secure in working with you and engaging with you, because I put in the just for you want to follow, we have a report over the situation of environmental human rights defenders in Mexico that we annually publish. And for example, just to close here, the last year we had 146 people that were killed in 2024 defending the land and the environment in the world. So this report reflects why we have sometimes problems engaging with communities, because they don't feel secure and they're afraid of engaging with judicial and strategic litigation before the courts in Mexico. Thank you very much. I'm sorry. I could go on and on and on.
I think my... Aline?
Yes, I will address just one aspect of this question that is related to language. So I think it's something very important when we are talking about strategic litigation to reduce this barrier regarding the language, you know. So there is a movement called Plain Language that was created in the 40s in the United Kingdom. And there is a lot of very good experiences in very different countries. That has two sides of this movement. It's not just the technicality of the language itself, but also it's a social movement. So I will share just two quotes that I think is very important. The first one is from Al Gore, the former American president. Plain language is a civil right. The second one is from Argentina, a very beautiful country, from my colleagues, Agostina and Connie. There is a judge there that is working hard in the plain language movement, and she said, plain language is much more than a trend, it's our new way of working. So saying that, I think it's very important to know that there are some initiatives in the judiciary that is trying to apply the plain language. In Brazil, we have a project called Petition 10, Judgment 10. So if you write in just 10 pages, you are going to receive a judgment in 10 pages in a much faster way. This is a way of trying to promote this. And also, there is a movement that is happening in the judiciary in Brazil as well that is trying to translate the Supreme Court's decisions. But I think that translating is not what we need. We need to create from the beginning a more accessible, friendly way of writing the law issues. So that's what I would like to share. Thank you.
Doesn't matter your final remarks, because my only task here was to retain time, and I thought a fiasco about it, so please go about it.
Thank you. I will say two things. I forgot about the San Juana case. We just filed legislative action, a law, the San Juana law, which gives the opportunity of incarcerated women to ask for a review of the case. Women that are incarcerated who had a final resolution, they can ask for a review of the case using the human right lens to understand the case. This piece of law that we presented as a citizen petition to the Congress in San Luis Potosí was last 2 weeks. It was accepted by Congress. So we have the San Juana law enforced in San Luis Potosí, which will give us the opportunity to review many cases. We are trying to enforce this kind of law in all Mexico. We are going to present 15 in 15 different countries the same law, the San Juana law, in order to have this ability. So that is also one thing that is important. The other thing that I was thinking about, plain language, we also started maybe 3 or 4 years ago asking Mexican judges to write the resolution, understanding there were small kids in the amparo. Since we were presenting the amparos regarding the education and regarding the schools, remember that the petition was filed by the kids. So we asked the judge to write something that the kids will understand. And this has been very beautiful because we have very nice resolutions. Some judges use even drawings to explain to the kids what is happening. And we have printed that and delivered to the school. The last time we do that, we printed and we delivered 300 plain language for kids resolution to the school, so they will understand what was happening. And it was also very, very, very important. It's also something that we want to do. And the third thing, and final, we have to change lawyers. We have to change lawyers. We have to change lawyers because and I'm talking about Mexico. Mexico is a very complicated country. It has a lot of unjust situations. And I don't see lawyers working in that. There's a very few lawyers working in communities, working in jails, working environmental, working in schools. I don't see them. I don't see them when we go to the communities. You don't see them when you go to defend the turtle. And I think we have to rethink our social responsibility. It is very important that the law firms rethink what we are doing, and I think we have to be very honest. We have our responsibility as lawyers in Mexico. It's something that we have to enforce a lot. And I think if we don't change lawyers, if we don't change the way lawyers understand the social responsibility they have in a country like Mexico, it's going to be very difficult to change these kind of situations. So I also invite everybody to give us advice. You guys that are from other countries, give us advice, give us experience, give us your recommendations. How can we change legal profession in Mexico? It's an urgent matter. We need to understand that legal profession has a huge social responsibility. Thank you for that. Thank you very much.
So I believe in terms of time, I don't know if what questions or otherwise, we want to appreciate it. We want to thank you very much. Now Daniela told me no questions. I do appreciate, they do have social media, you can interact with them through there. But I do want to appreciate all the three of you for interactions. I think they do deserve a round of applause again, because the work they've been doing is phenomenal. Thank you very much.
Una foto, si se pueden poner aquí. Espero que nos aparezca la pantalla azul y mil disculpas por el problema de presentación. Sí, para que se vea mejor. Gracias. Ahorita la saco. Mándamela. No, espérame. Tengo dos. Ven. Esta es la portada.
La que tiene una portada que dice todo comienza a los 15 años.
Sí, ok. Todo comienza con las trampas. Está. No, tengo solo esta, carajo. ¿Tienes tu compu?
Sí.
A ver, mételo aquí. ¿Rápido o no? O dame tu compu. ¿Lo puedo conectar?
No.
Una disculpa, estamos teniendo problemas técnicos, pero no va a alcanzar. Pero bueno, en lo que arreglamos el problema técnico.
¿Te la puedo mandar por mail?
No, es que no tengo mail aquí.
Porque tampoco entra el USB.
El siguiente speaker que está tratando de ayudarnos a solucionar nuestros problemas técnicos es Pablo Usoviaga. Pablo es cofundador de Arca Tierra y de Baldío, de Escuela Chinampera, y de, la verdad, un proyecto que por lo menos para mí está muy, muy cerca de mi corazón, porque desde hace muchos años hemos estado trabajando con ellos. Creo que la idea de esta closing session de Pablo es para cambiar un poco el tono y sobre todo recordar por qué hacemos todo lo que hacemos. Sorry, I'm going to switch to English. I completely zapped. I wanted to introduce our next speaker, which is Pablo Usoviaga, founder of Arca Tierra, Baldío, and Escuela Chinampera. You'll hear much more about that in the presentation if we manage to put it up there. I'm so sorry. But we wanted to change the tone a little bit and also remind everyone why we do what we do and who we do this for. So if we manage to solve our problems, you'll see very beautiful pictures, and especially coming from Mexico with impact. I think this is a project that has perfectly blended what a good structured project can do and the impact it can create in a lot of communities, and how we as consumers, as lawyers, as people can actually do systemic changes. So with that, I will thank you if you applaud while we try to make this happen. Maybe stretch your legs. Yes, exactly. And the good news is that after this presentation, we're we truly deserve our drinks, a couple of canapés, and a very nice, inspiring conversation if you can find someone next to you to have it with. So thank you. I promise this one will be quick. Okay, perfect. I will try. ¿Quieres empezar a hablar en lo que platican?
Deja ver si se mandó nada más.
Okay.
¿Quieres que yo le esté cambiando?
No. O sea, sí con el clicker. Here you go. Thank you, Pablo.
Thank you. So, I'm gonna start. If it happens to work, it'd be amazing because I'll show you some pictures that are gonna help a lot through the talk. Fíjala o no?
Sí, pero habla de ti. No.
Empiezo, ¿no?
Yes, go ahead.
Yeah, so as Danny said, my name is Pablo. I'm the co-founder of several projects, but I'll be talking about 2 projects today. One of them is called Arca Tierra, which is a regenerative agriculture network in central Mexico, especially located in the Chinampas and elsewhere. And Baldío. Baldío is the first zero-waste restaurant in America, and also the first restaurant to get a green Michelin star in Mexico City. So I don't want you to think I'm a hippie or something. I'm a lawyer, or I was a lawyer, but maybe once a lawyer, always a lawyer, of course. But I usually give this talk in different venues and audiences, especially for the hospitality sector. But now I changed some things about my speech and my talk, because one of the most important things I want to get through to you today is that sustainability and profitability, financial security in a business come together. You know, I would even go further and say that sustainability is even key in some projects to give them financial profits. And that's the case of Arca Tierra and Baldío. The key philosophy behind our projects is that we create closed-loop systems in every way. So I'll start with Arca Tierra. Arca Tierra, as I said, we work with a network of more than 55 families in central Mexico. Peasant families. I know the term peasant may sound a bit bad in English, but it's not. It should not be, you know. And I'm gonna go to it after in my talk. But in the surface, we grow food with more than 50 families in 6 different states in central Mexico. We recover chinampas that some of you may not know what a chinampa is. A chinampa is an ancestral method of growing food in some wetlands in Mexico City. Remember that Mexico City was built on top of 5 lakes. So we still have 200 kilometers of canals and chinampas. Chinampas are islands in the southern part of Mexico City, and they're disappearing. So we work in the chinampas, and we work with families from central Mexico. So on the surface, we sell ingredients to more than 75 restaurants in central Mexico, Mexico City. We deliver more than 600 seasonal ingredient boxes in Mexico. And we offer experiences. We offer people touristic experiences that go around agriculture and gastronomy, and we show them the chinampas. That's the surface of Arca Tierra. That's the part that makes the money, the profitability of Arca Tierra. But digging a bit deeper, what we really do is that we recover soil. Because we all know, and you should all know, that the health of the soil is directly related to the health of human beings. So we recover soil through this families and community network we've created over the last 15 years. We also have, of the 78 people that work in Arca Tierra, 47 of them are peasant farmers from Mexico. And we create this wisdom exchange with them, where we provide seeds and technology, and they provide food that's grown in a diverse way through regenerative practices. This started 15 years ago. My brother is a philosopher, and he came up with the idea, you know, recovering chinampas, producing food, and I just thought he was insane, completely crazy, you know? But yeah, 15 years later, he proved us right. I joined him 7 years ago because I realized that he didn't know how to make money in the project. And if a project is not making money, it's never gonna be sustainable in any way, you know? So I joined him, and I realized that there were many things that could work to make money through Arca Tierra, but everything centered on this principle that we want to give visibility to farmers and we want to recover the soil, you know. We also have a non-profit that's called Iniciativa Agroecológica Xochimilco. That's Agroecology Xochimilco Initiative, where we have 3 programs. All the programs in the non-profit are funded by private corporations. We've received money from, you name it, BMW, Anheuser-Busch, Santander, Vancomer, I don't know, like 25 different companies in the last 5 years. And one of the programs, it's called Adopt a Chinampa. The problem with the chinampas is that they're abandoned, like elsewhere. Like peasant farming is it's not well paid, it's not well seen. So nobody wants to work in the chinampas. And what we do with the program, Adopt a Chinampa, is that we just locate an abandoned chinampa, which is not difficult because more than 65% of them are abandoned. And the problem with abandonment is that the city starts devouring the chinampas if they're abandoned. So we recover abandoned chinampas with our agricultural team. Second, we have a farming school. The farming school, this is our 4th generation of the farming school. The farmers that work or learn in the farming school are the ones that help us recover chinampas. So that's when we start closing the loops. And we also have the 3rd concept through the nonprofit that's called Master Chinampa. In English, it sounds a bit weird, but it's like Mother Chinampa, no? Chinampa Maestra in Spanish. And the Chinampa Maestra is a chinampa that we rent, we lease. It's not ours, it's the only one that's not ours. And we offer free workshops given by chinamperos, by local chinamperos, to the community, so that we can bring back chinamperos to the chinampas, or young generations to the chinampas. Because as you may well know, every time a chinampero or a farmer dies, not a new one is born, you know? And they're the ones that feed us, so we know the extreme importance about it. And in the deepest sense, Arca Tierra is about giving visibility to farming communities and to farmers because as we call them, they're the guardians of the earth, you know? They protect soil, they protect the air we breathe, the water we drink. They have 70%, if I'm not incorrect, of the world's natural resources in their hands. And beyond that, they give us, in Mexico at least, and in many other countries, they give us our culture, our cultural identity, languages, recipes. So it's much more than just food, you know, although food should be enough. They also bring some of the deepest solutions to the crisis we're running to. They give us food sovereignty. They also help mitigate migration. They give us the biggest tool, which is food, against climate change. Like, we really think, and we're pretty sure, that the biggest tool we have against climate change is food, you know, changing the food industry and how we grow food and how we eat food. And they also give us our cultural heritage, you know. There's a lot of lies spread out in the media, and we've always heard that small farming communities are not able to feed the world, but it's, pardon my language, but it's total bullshit. Because they've been doing it forever. 70% of the food we consume, we eat, comes from farming communities, small farming communities. And they only use 30% of the land of Earth. And in the other way, 30% of the food we eat comes from the industrial scale, full of chemicals and poisons industry, and they use 70% of the Earth, you know? So that's an important data to chew on. So, well, we talk all the time about farmers and farming communities. One question that we always have is why, if they are so important to all the things I mentioned, why are they not valued as they should be valued, you know? Why are they not our role models, you know? Like I said, some people say there are technical barriers, you know, that they are not able to feed the world. But there is plenty of data that shows that's just a lie. So we think the barriers are cultural and symbolic, you know. I said that in English the word peasant is a bit, it sounds a bit bad, I think. When I say in England, or in the other time I was invited to a conference in Denmark, and they were all like, why are you calling them peasants? But in Mexico it's different, you know, because the word campesino, after the revolution, took a different meaning. And the word peasant means people that are not part of the system because they don't need to be part of the system. They produce food, you know? They don't need to be part of the system we created for them. So why are they not our role models, you know? If they have everything we need, they're the guardians of the earth. What would happen if instead of having someone like, I would just say a name, like Elon Musk, as a role model, we would have peasants? I mean, the difference is extreme. Peasants teach us that cooperation is way more important than competition. They teach us that generosity leads to a much better world than accumulation. And in my opinion, what I've learned through these 15 years living with them and like watching them and spending time with them 6 days a week, like I just came from the Chinampas today, is that like the Chinampas that were human-made, human beings not only can, but must have a positive impact in nature. And it's weird to say it that way because not only that, we think that we are part of nature, you know? Human beings, the main objective of human beings, as one of the Chinamperos told me, is guiding nature from simplicity to complexity, and guiding nature in order to be more lush, you know? It's part of us, it's part of who we should be. And nowadays that we hear that everything's going to hell and the climate crisis and everything, we must always remember that human beings can and must have a positive impact. So if we take the Chinampas and the peasants and the peasant communities as examples, we realize that. That's when we close the loop, we realize that we must and we can have a positive impact as human beings. Then, after 15 years running Arca Tierra and selling to almost 75, 80 different restaurants in Mexico City, we decided we were going to open a restaurant. So we opened a restaurant a year ago. Yeah, a year and a month ago. And it's called Baldío. I'm not going to get into the name and why we decided to call it Bar and Land. That's Baldío. But it's very symbolic. And we decided to open a restaurant because we know that restaurants nowadays have a lot of impact in the decisions people take around the consumption of food. And we decided to open a restaurant with the only project, the first project around zero waste in the world that's called Silo, and it's a restaurant in London. So we decided to open a restaurant with Silo in Mexico. And the principles of the restaurant are, of course, zero waste and regenerative agriculture. Everything we serve in Baldío comes from central Mexico, from peasant farming communities, and everything that comes in through our door ends up in the dish. We waste less than 5% of the food that comes in, and it ends up in compost, and it goes back to Chinampas. So why did we open Baldío? It's mainly to prove a message that doing things the right way and in a sustainable way can also be better as a business model. For instance, the cost of food and drinks in a normal restaurant goes around 30–35%. Our cost of food is below 15%. I mean, we've earned a Michelin star, you know, so food is delicious. It's packed every day. And the kind of message we want to convey is why, if it's possible to do it, not everyone is doing it, you know? Why, if it's sustainable and financially viable, why is everyone doing exactly the opposite? So that's why we opened it. And the principle that goes behind Baldío, it's pretty simple. It comes from a gardener that lives in Paris, actually. And it's doing everything in favor of nature, everything you can in favor of nature, and the least you can against nature. I know it sounds dumb, but it's pretty important. And yeah, I had some slides that I wanted to show you. Don't worry, Danny. That I wanted to show you, and maybe it's for the best because some of the slides are how we prepare some dishes, and I'm going to tell you a bit about it. But other principle we think is that waste is it's a failure of the imagination. You know, we created waste. It's not as if there were bins in nature before humans. You know, so if that's true, we could definitely go ahead without waste. And in Baldío, we don't have a bin in the kitchen. Well, of course, we have a bin in the restaurant. If you go there and you have a plastic bottle, you can come in. You can throw it in the bin. But in Baldío, we don't produce trash, only compost. I'm not going to get deep into the subject of zero waste because, as I said before, this is not an industry, hospitality industry or restaurant industry presentation. But the pillars of zero waste is that if you deal directly with nature, with farmers, fishermen, etc., you don't get waste in the system. You know, you don't buy an apple with a plastic bag because why would you put an apple in a plastic bag? You know, you just get it from the trees and you get it delivered to a restaurant. The same with the fish, the same with the meat. And the other thing is that every ingredient that comes in through the door is used in its entirety. we work, of course, with Arcatierra, and we close the loop because it's the Chinampas, then it's a lab and a prep kitchen we have, and then it goes to the restaurant. And I'm not gonna go, these drawings were, of course, for that, but it's, as I said, it's not that type of presentation. But for instance, we have in Baldío a dish that's pork tacos with mole, you know? The tortillero is made from the ash that comes out from the grill in Baldío, and it's beautiful. You know, we're gonna even open a business of biomaterials for restaurants because everyone asks for it. The kimchi we do comes from the stems of the broccoli that nobody uses in any restaurant, and they just throw it in the bin, and we turn it into kimchi. The mole comes from the solids that are discarded from a different drink we make that's called tepache. That's a fermented drink with tamarind. So every dish that's designed in Baldío has a system, and it's a closed-loop system. So it's not only in the macro scale, on the macro scale, the closed-loop systems, but it's also in every dish we create. And maybe the biggest impact that it has is that money goes to the right hands because there are no intermediaries, as I said before. We've also created a big network through Baldío in only 1 year, where restaurants like Puyol or Maximo or Rosetta give us their discarded ingredients. And I mean discarded ingredients is things they don't use for their kitchen. It's not the waste in the dishes that some customers leave, okay? So it's like, for instance, Maximo cooks a lot of fish and a lot of lobster, and the parts of the lobster and the fish they don't use, they send it to Baldío, and we transform it through a fermentation process with a Japanese mushroom called koji, and we turn it into fish sauce or lobster sauce, and then we sell it back to Maximo. So the only money we spend creating that is energy and time, because we have every ingredient coming from the restaurants, and then we charge them for it. You know, so that's also part of a closed loop system. And of course they can say that they're beginning to turn into a close to zero waste restaurant. So it's a win-win. The same with the drinks, you know. We have drinks that are made even with the olote, that's a part of the maize that nobody uses. We turn it into vinegar. We're innovating in a way that almost no restaurant, I would say, in the world is doing, because we have more ingredients than Silo in London or the Scandinavian restaurants like Noma in Copenhagen, and we're in Mexico. And we have all this biodiversity and this technology, that it's ancestral technology mainly, because it's fermentation, you know? It's fermentation, and it's things we already knew. So we're creating this closed loop system that every restaurant could and should be able to replicate. And the same with the materials. Everything in Baldío comes from a closed loop system. And just to close my small talk is that it's not only about ingredients, it's also what happens inside Baldío. In Baldío, we don't have a head chef. We have a horizontal structure. Almost everyone in Baldío earns the same, almost everyone. 35% of the shares of Baldío will go into the waiters and chefs and cooks and los que lavan los platos, you know, it will go to them in dishwashers in less than 3 years. So Baldío is not a project just to make money for Arcatierra or Silo London. It's a challenge to show that we can challenge the system, you know? As a message I would like to convey to you, that I heard amazing things in the last talk. I wasn't able to be here before because I was in the Chinampas in an event doing some stuff, is that there are two things that I've learned in these years. And the first thing is that apathy is the enemy, the biggest enemy against change. And apathy comes from not acting and not caring. And I think the sustainability conversation and arguments have failed, like enormously failed. No one considers sustainability sexy. Sorry for using the word, but I think it is that way. And it mainly comes because we talk about pessimism, you know, like everything's going to shit. And people don't react to that. So we need to be more optimistic. We need to show that there's a path, that there's a way. If not, nothing's gonna change. And we need to know that every action we take as humans, as persons, not as a community, but just as humans, do make a difference. If you decide not to buy a plastic bottle, and instead you drink water from, I don't know, from a glass, from a jar, it makes an impact. And the biggest threat to us, in the same level as apathy, is thinking that someone will save us. Corporations won't. We know that. Technology won't do it. We already have the answers. We just need to apply them. And that's it.
Gracias, Pablo. Todo. Thank you very, very, very much, Pablo. Yes, we have a question. Wow. Where is the restaurant?
It's in Condesa, here in Mexico City.
Let's go.
I'll give you my number and I'll make a reservation for you.
Thank you so much, Pablo.
No, you're welcome. Thank you for inviting me.
Este también. So we have some good news. We gave the catering team notice that we're going to wrap up at 18:30, so that means it's just 10 more minutes. So that's good. Because I know that everyone's probably very tired, everyone wants to talk, and they want to share a drink. So we want to make these wrap up very, very short and very sweet. Even shorter.
No, I have something to tell Paola.
But so just, I wanted to invite everyone, yes, to just stand up for a second.
Please.
And just stretch your arms, try to be calm, because we are finishing the 3 most impactful days of a legal team. Woo! So you can breathe in, breathe out, so we can start closing. So go ahead, Paola.
And we wanted also to invite you to close your eyes and to do something that we have not been doing for the past 3 days, and that it's quite uncommon in our modern society, and it is to listening to ourselves. So for 30 seconds, we're just going to be silent, and we're just going to try to remember something that for us meant something during the past 3 days. Eyes closed. There's video, so we know. The wisest and most important person in your life is you. Just keep your eyes closed. And if you're able to listen to yourself, I assure you, you're gonna convey words and thoughts to other colleagues that will inspire them. So keep on listening to that wise inner voice. And before you open your eyes, I'm just going to read something. The law, at its core, is a social science. It's a living reflection of who we are and who we aspire to become. And it doesn't exist in isolation. It is not written cold pages, but it is the warmth of human relationships. In every effort to make justice tangible. When we see law as a social science, we remember that its true purpose is not to control, but to connect, to design, to heal, to turn collective values into collective progress. So before we open our eyes, I will invite you to do something that might seem simple, but it's quite daring, and it is what we're being asked to do all the time as impact lawyers. And it's just trust that if we move, that if we just try to, put our feet forward, there's gonna be ground there. There's gonna be something that's gonna grasp our idea and that will help us move forward. So right there where you are, not opening your eyes, just take one step forward, first 1 foot, and then the other. And we just need to keep on doing that one time and another time until we get to where we want to get. Thank you so much. Gracias, obrigado, grazie, sheshe. Thank you so much for being here, for taking that step, for sharing, for moving, for everything you did for the past 3 days. Thank you. You can open your eyes.
Thank you, Paola. And as you see, Paola is the sensitive one, the one that moves her heart, and I'm the talkative, as you can see in all of the panels, and I'm the one that is wrapping up every knowledge that we have today. So if you can sit out, it's just a 3-minute lecture that wraps what happened in these 3 marvelous days. So as we close today, the Gale Summit 2025, I want to begin by saying thank you. Thank you to each of you who believe in this transformative legal gathering, a space of purpose, connection, and action for impact. Thank you to everyone who made this journey possible, to those who dream it, plan it, and work with so much dedication for an entire year to make it real. To our Gale Latin American team, especially to Ivana, Daniela, Agostina, Connie, Ana Lucia, Magda, Paola, Jameson, Aline, that thank you for your passion, your perseverance, and your deep belief that this region could lead a global conversation on impact law. To our Gale Global colleagues, especially our president, Michael, and all Gale members who support us every step of the way and traveled from so far away to be here. Thank you for your trust, your generosity, and your friendship. Special thanks to Sarah for being here from the Gale team. To Ricardo, Pamela, and everyone from the Universidad Iberoamericana for opening your home and heart to host us today. To Hogan Lovells as our sponsor, to Danny and Taide for all coordination, logistics, and care behind the scenes, and all of the Hogan Lovells team. And of course, to our sponsors, BILAB and Promotora Social Mexico, to our panelists and every single participant. And thank you for believing that the law is part of the solution to create impact. We began this journey with the Latin American Day. Listen to a heartbeat of a region that turns adversity into innovation and solidarity. We heard voices that remind us that the law, when guided with empathy and conviction, can become a tool for equality and transformation. And they touch our hearts, reminding us that our work aligns with Gale's mission to grow the next generation of impact lawyers who advocate for people, planet, equality, and truly sustainably and inclusive economy. That day shows us that purpose is not a concept. It's a daily act of courage. have to turn the picture. Then, on the Members' Day, we reflected on who we were as a community and what kind of leadership we want to embody. We spoke about purpose-driven leadership, about building bridges across regions, and about how can Gale remain the space of collaboration, generosity, and collective strength. It was a day of vision, a day of commit ourselves to lead not only with expertise, but with empathy and integrity. And today, during the Global Day, we open our perspective to the world. We listen to inspiring discussions and saw how every local action can become part of a global movement. We realized that impact law is not a small field, it's a bridge, connecting disciplines, regions, and generations in the shared pursuit of justice, sustainability, and peace. Over these 3 days, we have strengthened the global movement of impact lawyers, people who believe that the law can heal, protect, and transform, who give voice to those unheard, and safeguard what sustains us all, people and planet. And we want to say from the bottom of our hearts, thank you for coming to Mexico. Thank you for being here, for sharing these days with us, and for discovering how extraordinary this country is, not only for its culture and beauty, but for its people who believe that change is possible and impact begins here, no matter our intern right now, our surrounds right now. Mexico will always open its doors to you, to keep imagining, creating, and building a better world together. So we live tonight. Let's carry us with the courage of Latin America, the wisdom of our members, and the vision of our global community. Let's keep building with humility, creativity, and hope, because the future of impact law is already being written by all of us together. And before we close, let me say this. This is not a farewell. This is an invitation to meet again at our next gathering, to continue the actions and plans we begin here, the connections we build between people with hearts and minds committed to impact will bear many fruits, and I hope that our next meeting we can celebrate them together. Without a doubt, this is an emotional moment for all of us. So until our next encounter, thank you for being part of this journey, for your energy, for your inspiration, and your belief that law can truly shape a better world. Thank you very much. So, we are going for drinks that Promotora Social Mexico invited us a cocktail today. Thank you very much. Sorry. Picture of the board of LATAM, and then they ask it, sorry. Not my suggestion. Celular, Rosa. Ya olvídenlo, cóctel escalera.
Sales aquí, participas en el jardín, donde fue toda la comida y todo.
¿Ah, sí?
Ajá, ahí va a ser el sí, ¿no? ¿Sales? Y comen saliendo de las escaleras.
No.